Mr. Daly? What would you like?
So Judge, two things. I've talked to Madam Prosecutor on this case, Judge, and I'm approaching on two things. One, bond reinstatement and PC on this case, Judge. She and I have already discussed it on this case, and we just both want you to hear the PC if we can, Judge.
Okay.
And then on the bond reinstatement as well, Judge.
So officers initiated a traffic stop in Harris County, Texas for a vehicle having a fictitious plate bearing the word traveler on it. During the stop, the defendant refused to provide.
Traveler? Okay.
During the stop, the defendant refused to provide ID or insurance information, stating, "I do not consent to this." Officer attempted to remove the defendant from the vehicle, and defendant actively resisted by pulling his arm away from deputies until he was detained.
Okay. Tell me what.
So we looked at, well, I'm sorry, Madam Prosecutor, the interference with duties of public servant, Your Honor. Even if my client is failing to give them that, then it is an arrestable offense. But in this situation, it is, Judge. However, in this particular situation, he didn't interfere with anything in terms of his own arrest. I can, if it was a resisting or something to that effect, I can.
They're just trying to get him out of the car.
I don't disagree.
It's classic sovereign case where got the license plate, think that traveling by right is what I think how they term it.
In this situation, Judge, and the reason I'm employing upon the court is, even from what Madam Prosecutor has seen on the video, they're pulling and tugging at his arm, which put my client in some fear. It was more than one officer. It was pretty.
But he still has a duty. If they're asking you to come out, they can lawfully do that. And there are videos, and go on YouTube, right? There are hundreds of videos where officers will literally destroy your car to get you out. When you get into a pissing match with a person who has the power of arrest, who's going to win, Mr. Daly?
We don't disagree, Your Honor.
Right. You know what I mean? That's real life.
We don't disagree, Your Honor. I think under the circumstances of what actually happened, it was not Mr. Daly's position to resist or to interfere. That was not. He was concerned for his safety at that point. And actually, I don't know, did you hear that on the video? Right. And so in reviewing the video, it was pretty quick, pretty brash. They didn't give him an opportunity to respond per the prosecutor. In this situation, it wasn't as if he was intentionally
Remember,
not.
this is just a mere probable cause.
Yes,
So,
Your Honor, I agree.
they ask you to come out of the car one time. Yeah, it's really, so, I think that there's enough probable cause to go forward now. The problem is, Mr. Daly, is that we revoke your bond. Your bond is set at 2501, and you've continually failed to appear. So, the case and the way that you've treated us, it shows me that you just refuse to accept authority. How are we supposed to deal with that? How do we deal with that, Timberland?
Your Honor, the only reason I bring to your attention is I asked the court to take into consideration, we have a Black male works every day who, and I hate to put that on the court, but I do in this particular climate, that has never been in contact with any particular law enforcement court system. And from what I can see and what I hear out here from a lot of my Black male, and I'm sure it's common knowledge, is that because they are unfamiliar with the court system, they don't know, number one. Number two, when they do come in contact with police, and my mother is assistant chief of police, so I can understand, even when I was younger, I was taught that there are certain things that you have to do with when a police officer even stop you on a speeding ticket. What we don't know is whenever these officers come up, when you're somebody who don't have the privilege of having a police officer as a parent, or who isn't familiar and is being raised in this particular climate and seeing what they see on TV and seeing what they hear and everything that has occurred, you don't know what the proper steps are. I was trained from when I was grown up what you do. I'm not saying that what he did was right or wrong. I'm not saying that how he reacted to this particular court, it is wrong. However, I'm employing upon the court to ask the court to take into a little bit of consideration. Number one, from his perspective, all defendants, can't just say this, but I do see that, from what I've known from this particular case and now in talking to him, I do believe that there is a sense of, sometimes they just don't know. Sometimes they just don't. So I'm asking to reinstate his PR bond. I am now on the case. What you know about me, I'm a tight attorney. I run a tight ship. So, and by which of way I believe I can reach him and getting him to court and resolving this matter, which is what I talked to the prosecutor about when you were on break. It's like, let's just resolve this. Let's take care of this.
I'll buy it.
Yes, sir.
Okay.
Thank you, Judge.
I'm not going to do this again, though. I promise you. I don't care whoever you have. If you flake on us again, that's 3 times. It's out. I'm not going to do it again. Do you understand, Mr. Daly? I mean, when you come to court, good things happen. When you don't show up and you continually do it, you can't expect good things to happen. Now, do you have a Texas driver's license?
Not right now.
You're not allowed to drive.
Right.
You have a bond condition and you've signed an affidavit with me today promising you're not going to drive. I don't care how you term it. Driving, traveling, however you're going to word it, whatever you do not get into the driver's seat of an automobile, a motorcycle, anything with a combustible engine where you can get on the road unless you have approval from us. Do you understand? I don't care that you have to work. I don't care if you have to go to church. I don't care if you're going to a funeral. I don't care if you're going to wherever it may be. Do not drive. Do you understand? Heed this warning. You're not going to get another one. Okay, Timberly, I'll reinstate the bond.
Thank you, Your Honor. And I'll talk to her. We were going to try to talk to Chief, but it's pretty busy
I
today.
think the case is only 3 months old,
Yes,
so you've got time. You can do whatever you want.
Yes, sir. Thank you, Judge.
Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court now, but you must stay in touch with her and she'll tell you when you got to come back to court. If she comes back and tells me she can't get a hold of you because you're playing games or you've gone AWOL or whatnot, or you get arrested for something else, all bets off. We good? I'm not asking for much, man. Really. And for future reference, when you get into a pissing match with someone with the power of arrest, you are nearly always going to lose. It's just the way it works. And as a young Black man in today's society, you got to be extra special careful because things can go really wrong really quick. And there's evidence of that over and over and over. Okay? All right. Good luck, guys.
Thank you, Your Honor.
Yes, ma'am.
Thank you, Judge. Thank you. Thank you. You want to show this to Chief?
Yeah, I just.
And here's the plot twist. Running from police and crashing into a tree is already bad. But having a gun in the car when you're underage, that's a legal cocktail shaken over a flame. The judge is about to go full life coach mode on this kid. Watch the shift from criminal procedure to tough love motivational speech.
Thank you.
Of course.
You're Stephen Benito. Mr. Benito, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On 4/29/2024 in Harris County, Texas, officers observed a vehicle run a red light and they attempted a traffic stop. The vehicle evaded for 0.59 miles, speeding 63 miles per hour in the 30-mile-per-hour zone before crashing into a tree. The driver detained the defendant got detained and was sent to Woodland Memorial Hermann Hospital for his injuries. Officers recovered a bag from the vehicle containing a firearm. So he ran a red light, they attempted a traffic stop, he evaded for 0.59 miles, and then they found a firearm on him.
Where was it? Don't say anything, please.
He was traveling southbound in the 29800 block.
No. I mean, like, where was the gun? I guess, yeah. No, it's a accompanying felony. Mr. Benito, I'm going to find that the probable cause is I'm going to find probable cause to go forward with the case. How old are you, sir?
Inside the center console.
You're 17. What do you do for a living, sir?
Not work. Company.
Are you in high school?
Online school. Online school.
What does that mean?
Yeah, I'm enrolled in online school.
Okay, I'm sending you for a drug test. And I don't want you to smoke weed. I don't want you to use the alcohol. I don't want you to have any weapons. Do you understand? Do you have a Texas driver license? You're not allowed to drive. You will be signing a promise with me today, Mr. Benito. I want you to understand that I take it extremely serious. You are only 17 and you're starting your life out now. You have an open third-degree felony. You're looking at up to 10 years in prison. This is not a good way to start life, man. Really. You have your whole life ahead of you, and I'm going to tell you, you end up in prison, it's a veritable nightmare. We're going to do everything in our power to make sure that you go on the up and up. I want you to stay in school. That's also a condition of your bond. Do you understand? I don't want you out in the middle of the night. I'm giving you a curfew as well. I'll give you a lawyer today, but we're going to work hard and fast to make sure that you go on the up and up. You understand? No more weapons and no driving. Who are you here with today? How'd you get here? Okay, don't drive. I'm not asking much.
Judge, it was in the center console. I just need to review the report.
Okay. This is an affidavit. This is a promise that you're going to make to me. And if I find that you drive, and I'm telling you, I don't care what your reason is, I can have a contempt hearing. You can be facing up to 6 months in jail and a $500 fine every time you drive. The problem with driving without insurance, Mr. Benito, is that if you get into an accident, and let's say you kill someone in that accident, who do you think they're going to come after? Right. No, not after you. They're going to come after the deep pockets, which are probably mom and pop. You don't want that to happen. You understand? Come on. So let's send him for a drug test. We'll have him come back, appoint a lawyer now, and then we'll, get with the lawyer to see how we go forward with. Happy with you, Mr. Jones. You've now picked up a third case. You now stand charged with failure to identify oneself. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 5th, 2024, officer initiated a traffic stop on defendant's vehicle for failure to display a front license plate while he was driving in the 5900 block of Mercer Street in Harris County, Texas. Officer made contact with the occupants and detected an odor of marijuana emitting from the driver's side window. All three occupants were detained for a PC search. The defendant provided the name of Kendrick Johnson with a date of birth of 8/30/2006, which returned with nothing. Officer used a mobile AFIS device and found defendant's real name to be Jamarcus Jones with the date of birth of 8/30/06.
I ordered you as a condition of your bond, and you promised me when you got here last time that you would not drive. Stop. Did you say that he was a driver here? Stop. Don't say anything. I don't want you. Don't. You have the right to remain silent. Exercise that right. I was under the impression, Rosette, that he's driving here. Is he not?
There were three occupants in the car, Judge. I'm trying to see if they clarified. He was a passenger. He was the front passenger, Judge.
Okay, so tell me, let's do a deeper dive.
Sorry?
Let's do a deeper dive. So they pull him over. He's the passenger.
There was an odor of marijuana detected.
So what happened next?
So they detained all three occupants for
Okay.
a probable cause search.
All
The
right,
driver was identified by his driver's license, and the front seat passenger, which is the defendant, provided the name of Henry Johnson. And a mobile AFIS revealed that that wasn't his true name. And so he was charged with failure to ID.
do we have any co-defendants in this case?
Yes, John Burns.
Okay. So what's the cause number on that?
On that one?
Yeah.
It's 25-417-01. That's in court 15.
Okay, is there a third co-defendant as well? Okay. Mr. Jones, I'm glad that you're not driving. Regardless, you've picked up a new case. I don't know what we're gonna do, but normally when you pick up a new case while you're on bond, we revoke the bond on the old case. So, I mean, it goes with you. I'm gonna appoint your lawyer today. We'll figure out how we go forward, but for now, I'm gonna take you in. I'm gonna appoint your lawyer. We'll see how we go forward, but you're supposed to behave yourself while you're on bond. You've now picked up a third case. You first have a felony theft, you got a second case, and now you've picked up a third case. It goes with you. Can you please, one on one? Hi.
Good to see you, Judge.
You too.
I'm here on Mr. Benito, Benito. Young man got appointed in this case this morning. And he's present here in the courtroom.
Okay.
A couple things, just a little bit by way of background. The state and I have talked about what I think may be some issues in the case. I think as far as a bond condition, he was sent over for testing. I think this is his first appearance here. My understanding is the results of the testing came back positive for marijuana. I've talked to him about the importance of not having that issue moving forward. So we're aware of it and we'll address that. I talked to the state about what I think is a legal issue that exists in the case. I don't know that it exists from a probable cause standpoint at this moment, because I don't know that the officers had enough in the way of developed facts. The interesting issue is our chapter 4602 statute about unlawful carrying of a weapon does not apply to a person who is traveling under the code. But I think that requires some factual development that was not within the officer's purview at that time. So I won't belabor the court with all those details.
Okay.
He's got the felony charge that's still pending. But we're aware and will not have.
And I think it's did you say it's 5/10 of a mile for the evading?
It's about a half mile. Yeah.
Okay, I thought it was something like 5/10. You said something like that. All right, Mr. Benito, we're not asking much. Don't use marijuana. I'm telling you now, you will be tested in 45 days. If you continue to use, what happens?
You understand, Judge?
You understand? Okay, I'm not asking much. Stay in school. Try to be the best person you can. Don't pick up any new cases. Don't drive because you don't have a license, and don't use marijuana. That's it. Were there co-defendants in this case?
No, that I see.
Okay,
Judge, I just put it together. 5/10 is a half a mile. But my math is slow.
they
so-
say 5.
0.59 miles, half mile, a little over half mile.
Ay, ay, ay. Okay, be good. It's not hard.
This is the judge's "I'm not mad, I'm disappointed" speech, but legally binding. Judges hate repeat no-shows because it signals disrespect for the court. And notice how he frames it? Not just about the case, but about authority. This is where defendants often lose sympathy fast. What would you say to a judge if you were trying to get a bond reinstated after multiple no-shows?
All right, Mr. Trevor, do you mind getting a cell phone, please? Do you have a pen or do you need one? I need your cell phone so I can give it to the lawyer. If you look on the TV, that is Mr. Gregg, who's been appointed to represent you. Your cell phone, please. It is your responsibility to stay in touch with him, Mr. Trevor. Thank you so much. It is your responsibility to stay in touch with him. You know what the expectation is here. Do you understand? Yes or no?
Yeah.
Okay. I'm not asking for much. I want you to be the best person that you can be. Believe it or not, we want to help you. We want to make sure that you amount to something in this life, not just do something. Do better. Be better. If he tells me he can't get a hold of you, if you pick up a new case, you violate conditions, I'm going to revoke the bond. It's very possible you will not get any more PR bonds. Do you understand? You got out of jail because you were given a free bond. But for those who are dangerous and for those who continue to violate laws, they usually do not continue to get PR bonds. I want you to know that. And I want you to know that we're going to protect our city at all costs. So what we'll do now is, have we had him sign a reset yet, Victoria? Mr. Trevor? Okay, so we'll just have you step outside. You'll be able to talk to your lawyer, and after that, you'll be free to go. All right? Okay, man. Greg, did you want to say anything?
No, just call me. We'll speak about your case. I'll look at everything. Was PC found already, Judge?
Yes.
Okay.
There it is.
I got his number. I'll shoot him a text right now. And then
I chatted you his phone number there. His phone number will be on your reset so that you will also have a copy of it as well. If you ever have any issues, if you lose your paperwork, if you're unable to get a hold of him, if you ever have a problem, all you have to do is come back here and we can help you out with whatever you need. If you need resources, whatever it may be, come back, ask, and we can help you out. But communication is key. If you don't communicate, we just can't help you. All right? Okay, man.
Judge, how much time did you want on that one?
You are Lawrence Bazil. Good morning, Mr. Bazil. So I see here you've picked up 2 new cases. You've picked up a violation of a protective order bond condition. You've also picked up a burglar of a habitation. It's alleged that on November 26th of this year, you've picked up these cases. I have no idea what's happened with these cases. Your lawyer's here with you. She's on Zoom. Please don't say anything at this point. I just want to find out what's going on because I don't know. So we're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Witness stated on August 29th, 2024, he and his girlfriend, the complainant, were home when the defendant appeared at the front of the property and told the witness that he wanted to kill him or kick his ass.
Okay, hold on. You're going way too fast. So who's at the home?
So the witness and the complainant are dating.
Got it.
And the defendant appeared at the front of the complainant's house.
Okay.
Told the witness that he wanted to kill him or kick his ass. The
Okay.
defendant proceeded to walk towards the front door of the house and enter the home without consent. The defendant then grabbed some keys from inside the house. The witness ran outside of the home and the defendant chased after him. The defendant began to hit the witness several times with fists. The defendant then snatched the witness's cell phone and ran out of the house. Complaining witness has an active 5-year protective order against the defendant that was issued on 12/6/23.
So that 5-year protective order is against the witness.
The complainant. Yeah.
Okay, it's a
So the
complainant.
complainant is the girlfriend, and that's the VPO. And then there's also the Berghaus, but I mean, it's the same complainant.
The complaint is my
Stop. Don't, please.
Hold on, Mr. Brazil.
I mean, really, just now's not the time. There will be a time, now's not it. So what problem did you have with anything, Ms. Oko? Or did you have?
So, yes, Judge. So he was arrested on a VPO on the 30th. The complainant
30th of
August. On the 30th of August for a VPO violation. So for them, for it's a bit, shall I say, unfair for him to be rearrested on a VPO for the day prior to the day he was arrested for the same VPO.
Well,
And he spent 2 weeks in
But
jail.
no,
on it.
but they're different, right? So read me if you don't mind, the VPO on 831.
Yes, Judge. So on 8:30, an officer was dispatched to a suspicious person call at the listed address in Harris County, Texas. The complaining witness had an active protective order stating the defendant could not be within 200 feet of her residence. On that day, defendant was walking on the sidewalk in front of her house, which is less than 50 feet away from the residence in Harris County, Texas. The complainant had a picture of the defendant on the sidewalk across the street from her residence within the 50 feet. Listen to the protective order.
So, and that was on August 31st, 30th. This new case that we have here now, this is from November.
It was filed in November, but it occurred on the 29th. So it's just a
Okay,
late
hold on.
filing. That's kind of the confusion.
I see.
And on the 30th, Judge, the complainant actually went up to the
Okay,
police
so
station.
here's the, I don't understand what really, I mean, okay, so here's what it looks like. The first VPO that we have here was for the August 30th case. So what it essentially looks like is we have two VPOs happening one after one day and then another one happening the next day. But it looks like I don't understand why,
It's
but
different filing officers. So, I mean, in the first VPO that he was convicted in, the officer filed it the day after. He filed it on the 31st. For some reason, they sat on it until 11/26.
hey, guys. Your camera. Yeah. So this new case happened 8/29 versus the one that he pled to in September happened on 8/30. So
He
this is
pled
like
to-
what she's saying, it's a late filing and it happened the day before that other VPO. You know what I mean?
So I'm reading the DIMS and it actually, so the mom went the next day to the police station to complain about yesterday. That's what I'm reading on the DIMS. She goes to the police station and she says, hey, he's been to my house. He went to my house yesterday and now he's on the crosswalk. So essentially they, on both of the DIMS, they're adding 2 of these days on the same thing, on the same DIM. So she's complaining 20th and the 30th.
We have a 911 call from the incident on the 30th, and it says the officers were dispatched to the house. So I don't believe it was a walk-in report.
I'm literally looking at it and it says that she came to 1200. The complainant appeared at the Houston Police Department Family Violence Unit located at 1200 Travis, and she stated that her son stated the defendant was her son.
Yeah,
I'm reading it.
that's my mother.
Don't,
Mr.
please.
Bezel, hold
Have
on.
someone on your
That's for the
behalf.
most recent VPO. I'm talking about the original VPO. There's a 911 officers were dispatched. The one on the 30th.
That's what I'm saying. On August 30th, 2024, the complainant appeared at the HPD on 1200 Travis, and she complained about yesterday, the 29th event, and the today's event. I don't know if there's a today event, but
So, okay, it may be so, but they're two separate offenses, right? Maybe she's complaining about it. At the time, she's complaining about two different things, right? Because they're happening in successive order. But I guess technically to the filing, and there's still two separate incidents that occur. Are you saying you're saying it should just be one VPO and not two?
I think I figured it out.
Okay.
Yes, she made a walk-in, officers were originally dispatched. She made a walk-in report and she told the officers that the defendant went over to her home wanting to fight her boyfriend. The complainant stated the defendant left when he found out her boyfriend was not home at the time. That's the VPO, or that's the violation that happened that he pled to, I believe. And then the defendant returned to the home to try to fight the boyfriend. That's when the bird cab and the second VPO happened. So these are two separate trips to the house. It's just the filing's messed up.
You need to talk to your lawyer and then she can.
no, I'll explain to you, Mr. Bezel. Don't worry about it. So essentially, there are 2 different days, even though they happened the one day after the other. She complained the second day about both of those incidences. That's when the officers went to the house to arrest Mr. Brazil, which I think is confusing, because if she's complaining about him coming to the house the next day and they go and arrest him that same day, then it's essentially both VPO should have been filed at that time. I
mean, I think I need
Once
to
again-
call the officer. I'm not prepared to make any, decisions on these cases
Why
right
don't,
now.
why don't we do this? Let's roll it to tomorrow. Are you okay with that?
Yes, Judge. I
This
mean,
gives-
Mr. Bill, he's here on the Berghab anyway, which he has not made bond on, so he's still here.
Well, that's true. So you've got the open felony case regardless. So let's do this. We can roll you to tomorrow. This gives you the opportunity to speak with Ms. Oko. She can do the research she needs to do. It gives more time also to your lawyer to do any other research that she needs to do, and then we can get together tomorrow. And don't. I know you have to understand that anything you say, they're going to use it against you. I know that you're trying to help, and I've seen so many instances where someone tries and they think that they're helping themselves, and then they end up admitting something they shouldn't say, and it helps makes the case. Okay, so what we'll do is we'll have you put you back in back. I'll have Ms. Oko reach out to you. You guys powwow. We'll bring you back tomorrow, and then we'll see what. Yes, yeah. I'm gonna have her call back over there right now, so you guys can talk. Okay? Yeah. I know that you're itching to talk to her, and we're gonna get you right now. 2 minutes.
Okay, pause here. The sovereign citizen energy just entered the chat. Anytime someone says they do not consent during a traffic stop, that's your early warning alarm. Legally, refusing ID during a lawful stop is a fast-track ticket to getting pulled out of the car. Question for you all. Do you think the officer escalated too quickly here? Drop your thoughts below.
Good morning, Mr. Colegio. Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 30 days in jail, credit for the 12 days that you've done. You need to understand that this is going to go on your record. It's going to be there for the rest of your life. What happens next time?
I won't be here next time, sir.
If I had one strand of hair every time someone told me that right there, I would look like you with hair. Really. If I had one strand. You need to understand that both of these are going to go on your record. They'll be there forever. Even if you have a sip of alcohol, if you get pulled over, an officer's going to see DWI, they're going to probably take you right in. From now on, you're facing a 3rd-degree felony, 2 to 10 in the penitentiary. Do you understand?
Yes, sir.
So I wouldn't get in the car even if you've had a sip of alcohol, because if you thought this was bad, wait till you get to felony court. You're giving up the right to a trial, right to compel witnesses. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it goes on your record. You can never take it off. You understand?
Yes, sir.
You still want to do this?
Yes, sir.
How do you plead to the offense, sir? Guilty or not guilty?
Guilty.
It's alleged that you had an open container. Is that true or untrue? Did you have an open container of alcohol in the car?
Yeah.
I did discuss that.
I'm going to abandon the second enhancement, but that's an enhancement that makes it a minimum of 5 days in jail to the case, which you've already satisfied it, obviously.
Okay.
But it's still an enhancement that they have on there. They actually have 2 enhancements. Your second enhancement is one that you had. Actually, there's 3 enhancements, actually. So it's also alleged here that you had a prior DWI in County Court 5 in Montgomery County. Is that true or untrue? It's also alleged here that you had a .15 or above. Is that true?
I would, due to the actual results, I would ask them to abandon that one.
Okay, I'll abandon that one. I got to look to see because that one might make it 90 days though.
The NTC code has to change. Because it's a DWI second with the 0.15.
It's a second.
with a 15.
Okay,
So we need to, so
because it is a 0.14 and a 0.15, so I would.
do you know what the new NCIC code
It
is?
will be just a DWI second, right? I don't
Yeah.
know.
Yeah. I don't have, do you guys have the NCIC code for just a DWI second?
I think it should be the 14.
I don't know. I want you to understand that there's another big thing about this, Mr. Colegio, that DWIs are big business in Harris County. You know, this right here, there's a $6,000 surcharge that goes on you because this is a second offense, plus court costs of around $500. So because you're in custody now, I'm gonna end up waiving it because you're in custody now, but the more DWIs you pick up, the worse life gets. And it's so easy. All you have to do is hit one button on your phone, $40, and Uber will take you wherever you want to go, man. Don't get into a car again if you've had alcohol, because it's not gonna end up well. Did you find it, Janice?
Yeah, yes, Judge, I think, the paperwork may have to be refiled. I'm not entirely sure. But she's gonna work on it.
Okay with abandoning the 15 enhancement?
Last name again?
Colegio, COLL.
EGL.
So that would do. And what's the logic behind that?
Well, one of my fear was that it would make the minimum higher, but
Don't worry about it. It's pretty high. That's why I was That's what my understanding was. I didn't know that. Mhm. That's scary. That's why I kept it and it's minimum was 3. 30 is fine.
Okay, so I just say,
you would? Yeah.
okay, okay, yes, sir. That's right.
So we can continue with the plea as written.
Okay, so is it true that you had an open container? Did you have an open container?
Yes,
No, you were there.
Yes, yes, sir. Yes, sir. Yes, sir. Yes, sir.
Please.
Yes, sir.
Okay. Is it true that you had that prior to DWI?
Yes, sir.
And it's also true that you had a 0.15 or above?
Yes, sir.
Okay. You know how to act. You know what to do.
Yes, sir.
Just be good in the future. We're not asking much, you know? We want our streets safe. How do you plead to the offense? Guilty or not guilty?
Guilty, sir.
Find you guilty. I will follow the agreements for cost. So I'm gonna waive the DPS fees. I still need that order, please.
Yes, we'll do it.
And then, I am gonna suspend your license for a year. Do not drive. It's a DWI. It's a second DWI. You're
Okay,
pleading
yes, fine.
guilty.
Thank you, sir. Thank you.
That, look,
Fine, thank you.
you're gonna get out of jail.
Can I get an ID, like a regular ID to start working?
Well, of course you can.
Okay, I'm just asking. That was the reason I turned myself in.
Glad that you did.
Thank you.
You're getting out of here probably today. When you get out, don't start driving.
Yes, sir.
Call DPS. They can tell you how to get your license back. And then when you do things the right way, good things happen. If you go out there and you start driving, even though you gotta work,
Yes, sir.
Murphy's Law, what can happen will happen. You're probably gonna end up getting pulled over and you're gonna be right back over here.
Sure.
So do things the right way, good things happen. All right, good luck. Thank you. Thank you.
Yeah, Ben heard with me last week. I was in Cancun. I guess there's a DVR for positive alcohol.
He's out now. Don't want any more issues. Just. Don't want any more issues. I'm not asking much. Just do what you need to do. Really, you know?
Judge, pretrial, I talked to pretrial, they said they're gonna, they listed about the THC. I don't know how you want to.
God, it's only 70 days old too.
So Judge,
All this trauma and it's only been 70 days.
is that it?
Yeah.
The lab is back. There's no alcohol, which we expected that already. We're still waiting for drug analysis, but I think as soon as that's back and the state's ready, we just either just try it or, just try it. Let's get it done.
Is that where this is headed?
Well, I looked at I've evaled it, and I don't think it's the DWI. I don't think it's intoxicated when I looked at the eval, but but the state can't do a full eval until they have their labs for the blood. And
Tell me what you think.
I expect that.
I mean, I'm gonna tell you now, this has so much drama, Ms. Saba, that I'm like ready to pony it up with Justin as well. You know, I don't want to sit and wait another 6 months and,
Judge, we don't,
oh, that's wonderful. Hi, you look great. You know,
what were you?
It's gonna be
Jones,
an alleged drug case.
Oh, yeah, we don't,
Is there a
we just don't
DRE
have the
done?
toxicology
Was that
report
DRE?
yet, Judge.
I can hear you, I'm sorry.
DRE, shh. Was there a DRE?
Theory? Yeah.
We just don't have the toxicology report yet, Judge, so, and the case is only 2 months old.
I know, no, well, yeah, a little bit over, but yeah.
A little bit over.
How long do you think it'll take?
I think it should take 1 more month, because sometimes I've seen them take up to 4, but maybe we can give it like 1 more setting before we.
Yeah. Okay, we'll sit you off 30 days.
Still have them come in to do drug testing.
Yeah, just don't use, you know? All right, so we'll continue supervision now, Felicia.
Judge, just to clarify something, so you are permitting the usage of THC?
No, I don't,
So that's like the dilemma here,
I know.
so I don't, because we're just gonna continue about, we have to.
Yeah, I mean, how do we deal with this? I don't,
Let's hurry, the lab is back and eat
Yes,
out and try to.
I'm not down with you continue to use marijuana. I'm not down with it, Mr. Jones. I don't want you to use. There has to be an alternate method to dealing with issues.
See a doctor and all kinds of stuff still though.
Yes, yes, that's what you're supposed to do. You're not supposed to self-medicate.
He's not self-medicating, he's got a prescription for marijuana, and I know we've gone down this road already, so he's not self-medicating, he's under a doctor's orders.
He has a second DWI that's open. I don't want you using, Mr. Jones. Just the plain and simple of it. I mean, don't. Do you understand? don't use. And get ready, please. It's way too much drama. I'm ready to put this baby to bed one way or the other.
We'll reach out to the lab and do an
Please.
eval.
All right, I'm gonna do 30 days. I'm gonna continue it now. Don't use. You've got 40 days. Do you understand? Yes or no?
Sir.
Okay, get ready. All right, Dustin. Good morning, Mr. Hinojosa.
Good morning, how you doing?
Sir, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have two cases, actually. You've got the DWI. You also have the unlawful carrying of a weapon. I'm assuming that one is,
No, nulling that, right? Yes.
they're going to dismiss that second case against you. You need to understand that this DWI is going to go on your record. It's going to be there for the rest of your life. What you need to understand is that whenever you get pulled over, an officer is going to see this. If they smell alcohol or they smell dope and they come up and they look that you have a prior DWI, you think things will go well? Probably not. So what I'm telling you is that you now have this DWI that's going on your record. If I were you, I would never get into a car, even if you had a sip of alcohol, because you're taking a humongous risk. Do you understand? After today, you will also have a minimum of 30 days in jail for any other DWIs that you pick up. You can use this to enhance your punishment to a minimum of 30 days in jail. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal once you accept this agreement. You can never change this or undo this. It will go on your record. It's going to be there forever. Do you understand? Do you still want to do this? How do you plead to the offense of driving while intoxicated? What have you worked out, Mr. Morgan?
There's 1 year probation, 30 hours community service, no drugs or alcohol, random urine analysis.
So it's,
180 days.
so the agreement is this: for you to successfully complete this probation, it's 180 days in jail. We will probate that for 1 year. As part of the probation, you will do one victim impact panel. What about a DBI education class?
Judge, he has a, judge, that's fine, we can add that in there.
It's not in here now. And I'm going to tell you, Mr. Morgan, that if he doesn't do the education class, they'll probably end up suspending his license. I don't know for sure, but from what I understand, the rule is that if you do the DWI education, the DWI education, it doesn't suspend your license. But did you mean to add?
Add it in, Judge.
Oh, it was an oversight?
Accident by my
Okay.
part.
Got it. So you must do a DWI education class, a victim impact panel. No breath test refusal. If you were pulled over in a car and an officer asks you to submit their breath sample, you must take that sample. Random urinalysis. No drugs, alcohol.
He has 100 hours upstairs. Two guys
Do you have any children?
You're doing the 30 hours here.
Mr. Morgan, I was gonna,
About the community service. Yeah.
He's on a deferred in felony court as well, Judge, where he has to do community service anyway.
I was gonna
So-
take that off anyways. I mean, what
We appreciate that,
I
Judge.
normally do, what I think would be more prudent is if they have children to do like a parenting class in lieu of, but he doesn't have children, so I guess we'll just,
Judge, he's fully, so he's on his way to become a productive member of society, I imagine. Starting a family at one point, once he's a little more financially stable, will be where he needs to be. Still pretty young though.
you're on felony probation now. You have to have a freaking halo over your head. Because if you don't, you could go to prison for a very long time. Have you been to prison before? If you have any doubts, go online and look at how miserable prison is. It's not a fun place. And I will tell you, there are some parts of prison that the lights don't even go off where people sleep. You can imagine how you have no REM sleep, how much that will play on your psyche and your hormones. It's incredible how bad Texas prisons are. There's no air conditioning. It's freaking awful. If you don't believe me, go look it up. You're on this deferred now, so you got to behave. Do you understand? All right. If you violate this agreement, I'm going to issue a warrant for your arrest. I'm going to put you back in jail. I'm going to bring you right back out, and we're going to talk about whether you violated this agreement. If you violate this agreement, you're looking at up to 180 days in jail. Do you understand? Okay. There's the, what do you do for a living? How much money do you make a month?
Judge, it's contractual, so it's whenever he has business.
There's a surcharge and fines and fees, Mr. Morgan.
And yeah, if we could waive that, as he has a forfeiture pending that is about to make him completely indigent.
Forfeiture?
Yes.
Oh, they took the car?
They took the car and he has been without transportation, and he has been, it's been a struggle to make ends meet. So he's.
What kind of car did you have that they seized?
Okay.
Oh my God. Oh,
Yeah.
Lord.
Yeah, no, he was.
Is that like a $90,000 car? How much was that?
Yeah.
Yep.
You had him with that right there.
Yep. Yep.
Wow.
Good, and then.
You know, I will tell you, I routinely warn people here about when they end up racing, they do crazy stuff, donuts and this and that. When they pick up a second one, a lot of the times the cars get seized. We see it every now and then when it happens, and here it's tried and true. This is a second case, and man, that's a nice, someone's going to get a benefit nicely from that.
Yep.
I hope that you get it, you know, from now on. You don't have to say anything, but I'm just, really, actions have consequences, and that's a hell of a, man, I wish I had that kind of car. Here I am with a jalopy. Drive a nicer car than I do.
But with that being said, Judge, if you would be so kind as to waive the surcharges, that would be ideal.
We want you to learn from this, Mr. Hinojosa. This is your first DWI. I will acquiesce to Mr. Morgan, but I'm going to tell you, if you're not smart enough to consider how to get home on a night of drinking, you act like a child, we will treat you like a child. But the way we do it, the way that we spank you is with a ton of jail time, you know? Really, you act like a child, you'll get treated like a child. And I'm going to tell you, I'm waiving nearly $3,500 in fines and fees and surcharges from you now. But I'm going to tell you, a second DWI, it's $6,000 surcharge, not to mention court costs. So you can probably roll out of here with about $7,000 in fines and fees. You pick up a second one. Do you understand? Get a clue. It's not hard. All right, done. I need you to do a waiver for me.
Yep,
And then
sure.
I'll grant it for you. And then, all right, good luck.
Thank you, Judge.
As advice, could you say anything about like?
Oh,
We agreed to no device.
is that the agreement?
Yes, Judge.
Okay, that's it. I'm going to tell you, we're going to test you. I'm going to test you like crazy. So I know that you're not using. If I find that you use, one of the sanctions that we can do is either guardian interlock or a scram device. Those devices are hundreds of dollars a month. Don't drink. Don't use illegal drugs. Do you understand? Okay, man.
Thank you, Judge.
Great to see you like always.
Great to see you, Judge.
Okay. Good luck, Mr. Hinojosa. Good morning, Mr. Venable.
Yes, sir.
Mr. Venable, you're charged with 2 counts of assault. One is of a family member. On both of those, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay, Ms.
On January 21st of 2024 in Harris County, Texas, officers were dispatched to an AFM call. Officer met with the complainant. The complainant and the defendant have been dating for 5 months. The complainant and the defendant were arguing. The defendant pushed the complainant to the ground, causing her to scrape her right arm. While the complainant was still on the floor, the defendant stepped on her neck. Officer noted.
Stepped on her neck.
Yes, Judge. Officer noted redness on the complainant's arm and neck.
You know if it impeded breathing?
No, Judge. I don't, I can't, let me check. It wasn't charged as an impeding breath, so.
Well, I know it wasn't charged, but is it?
The DIMS don't say that she had any trouble breathing, but I'll look at the offense report, Judge.
And here's the other thing. The first assault is from October of 23. The second assault is from January of this year.
Yes,
And now we have a felony evading arrest on December 10th.
yes, Judge.
Were these 2Bs? Was he out on bond for these? Vic, do you know?
It looks like. No,
So
it
this is
looks-
Venable, who's now picked up a third case. He had 2 misdemeanors, one's from 23, one's from 24. Did we ever do PC or had he ever been on bond
No, Judge, it was just a non-arrival.
for the whole time? All right.
Judge, it doesn't say that she had trouble breathing, it just says that it caused her pain.
Okay, can you do probable cause? So that's the family member, right?
That's the AFM,
Okay,
Judge.
can you do the first case? Because I don't think we've done probable cause on that one now.
This is the AFM from January 21st. Oh, the ABI, the one before.
Yeah, the one before.
On 9/29/2023, officers were dispatched. On arrival, officers spoke with the witness, complainant's wife, who said that the defendant assaulted the complainant by slapping him in the face because the complainant's dog killed the defendant's girlfriend's cat. Then officers spoke with the complainant, who said he had invited the defendant into his residence to discuss the situation when the defendant said she should knock the shit out of him. And the next thing complainant knew, the defendant had struck him across the left side of his face with his hand, causing pain.
Mr. Venable, I want you to understand one thing, that I'm going to do everything in my power to protect my community at all costs. And if that means I have to make your bond extremely high, taking you into custody, kicking and screaming, I'll do it in a heartbeat. Do you understand?
Sure.
I'm ordering you as a condition, I'm going to find probable cause on both of your cases, and I'm ordering you not to have any contact with either of the people in this case.
Sure.
There's a protective order that has been issued in the family case. I would get to know it. Don't say anything. You will get the opportunity. Now is not that time. I'm telling you what the expectation is while these cases are open, and what the expectation is for you to be able to live in this free world. Because if you don't abide by these expectations, I'm going to take the free world away from you. You are not to consume alcohol or illegal drugs, and I'm going to randomly test you. You're also not to have contact with either of these people, not to be in possession of any weapons, and abide by the conditions of the protective order. If you violate those conditions of the protective order, the state can file a fourth case, a violation of a protective order. If they do, that is the capital murder of misdemeanors. It's one of the worst cases you can pick up, and you violate those conditions, I can have a hearing to hold you at zero bond. Zero bond, and I'll do it in a heartbeat to protect every person. Do you understand?
Yes, sir. Yes, Your Honor.
Do you have a Texas driver license?
I do, but it's just,
So you do not have a Texas driver license. I am now ordering you also as a condition of your bond not to drive. You will be signing an affidavit with me today promising you that you're not going to drive. I don't care what's going on in your life. I don't care what you got to do. I don't care where you got to go. You violate this, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car.
an Ubering to and from, so.
Don't. There's nothing you can say to justify. I'm not asking you. I'm telling you what the expectation is.
Yes, Your Honor.
We are now going to reset your case to give you time to hire a lawyer. So for now, I'm going to have you come up here, sign this order, promising us you're not going to drive. I will get you to Victoria where we will have you sign a reset. for you to go get a lawyer. You will meet with Felicia for your bond conditions, and after that, you'll be free to go.
So,
The one in there that has contact.
Got it. Okay, so Rosette, the order in the one that's signed by the magistrate is allowing contact, but I'm gonna issue one now so that he cannot have contact, okay? Just so that you know.
Also, I don't see a motive on the assault violence injury case.
Well, it's because it's not a family member case, that's why. You can only do one on the family member cases, all right? That way. John D.
Good morning, guys.
Hey, bud.
Judge, was that CHA? They like Victoria Venable. Oh, thank you.
John D.
Judge.
What's the word?
First on young Mr. Cuellar, Diego Cuellar. He's due back today because he wanted some getting his GED. I spoke to him this morning. He had to get an ID in order for him to get his high
I
school.
think he's supposed to come here with his ID today, wasn't he?
Yeah, he showed me a proof that he's applying for it. He hasn't gotten the ID.
Come up.
And he's got proof on his phone that he's been researching the GED program. So he's taken active steps towards the judge. He just doesn't have the ID in order for him to get the transcript. So that he
Fair, you haven't done
officially get in the
absolutely.
GED program. Right?
I have to wait for the school to mail in the transcript so I can get the ID. They said I need my old school record so they have proof of who I am. But I have my GED login on my phone. I can show you.
To go get an ID, all you have to do is go to DPS and get an ID, right?
If they're under the age, they actually have to have a student verification form from a school.
That's what he's waiting for.
I was there
He's got
yesterday.
the, he's got.
What school is this?
Calhoun High School in Port Lavaca. Calhoun High School in Port Lavaca. I called them yesterday. And they're gonna mail it.
The day before court, you call.
That was when I had my appointment for the DPS.
Okay, so how long are we gonna wait for you to get the ID to be able to start on your GED?
Well, they said they mailed it already, so probably it's like a couple of days, like 3 days.
So let's set it a week. Okay, all right, I'll see you in a week, sir. All right.
Okay, go ahead. Go ahead. I'll-
Judge,
I'll-
was
I'll
that
text you.
Cuellar?
Yeah.
Yes, that was Cuellar.
Okay, John D,
Did you
who's
get the
next?
results for his stress test?
Well, you sent.
Second, I'll check.
You sent him to get tested last time, but it hasn't been 30 days, Judge, because you wanted him to come back to show proof. So.
That's all right, John.
So I think by next time, he told me it's clearing out. So that's good. The next one I have, Judge, is, well, we have to approach on Mr.
Yeah.
Imamovich, Judge. They're gonna
With an
file
I?
it with an IMA.
Oh, you're dismissing it?
Yes, there.
Yes, Judge. So I think, so we had dismissed the ABI, but I don't think we ever got the MOA dismissed. And so he got picked up on a VPO.
So.
But we don't plan on moving forward with the
Okay,
VPO.
all right, I'll sign it.
Got it, Judge.
Thank you,
And then
Judge.
lastly, I have Mr. Johnson, but they are.
So there's the proof. You see that?
Well, hey.
Even if the case gets dismissed, the DPO still lives on.
There you go, Judge. But it's good news, right things being done.
Yeah, you're doing all right.
Mr. Johnson, they are seeking some chief discussion in order to get that off your docket
The
today.
case
I'm
is
just
not
waiting.
over.
No, I got you, but I just want to give you an update on it.
How much?
It might be off your docket today.